Hey, good morning, everybody. My name is Robert Beckman. I'm pleased to be asked to serve as moderator of this session. Before we begin, I'd first like to welcome everybody on behalf of RSIS and the Embassy of Japan to the continuing seminar series by our RSIS. Although you may have seen the notice, I'd like to inform all participants that the chat and raise hand functions have been disabled for everyone but the speakers. But questions are, of course, the comments are, of course, welcome. You're to click on the question and answer icon on the bottom of their screen to submit questions, and then we will be calling on you later in the session. In addition, I've been asked to remind you that inappropriate comments may result in them being removed by the administrators and you being removed from the event and barred from re-entry. Okay, with that, I'd like to introduce the session. The title of this session is International Law and the Rule of Law Approach in the Indo-Pacific Region. We have range of actors are threatening rule of law, undermining, endangering international waters. Expert panelists will give you three perspectives on this. We'll be first looking at perspective from strategic studies. John Bradford, a senior fellow of the Maritime Security Program at RSIS at NTU, will be speaking on this topic. John has a Master of Science in Strategic Studies from RSIS, former Navy commander, so he understands maritime security from a practical perspective. Research interests are focusing on Indo-Pacific maritime and security issues. Our second speaker is looking at it from an international law perspective. Associate Professor Makoto Seta is an associate professor at Yokohama University in Japan, studied at LSE and did his PhD at Waseda University in Japan. He has, again, a special interest in ocean governance, so he'll be looking at the issue through the eyes of the international lawyer with a special interest in law of the sea. Our third speaker hails from the Philippines. Although he studied in Japan, Associate Professor Benjamin San Jose, Assistant Professor of Japanese Studies and Political Science at Ateneo University in Manila. Did his degree in public policy. His current research is on Japan and public policy, labor migration policy, but he's also looking at Japan's changing public diplomacy in the ASEAN region. So he'll be looking at the issue from a public policy perspective. We'll then be opening it up for Q&A. So without further ado, I would like to ask our first speaker, my good friend John Bradford, to take over.
Great. Thank you very much for the partnership between RSIS and the Embassy of Japan to bring today's event together. And thank you, Professor Beckman, for the kind introduction. Let me now share my screen and get started. Okay, I think everyone can see that, so I'm going to get rolling. I wanted to take a few minutes today to talk about challenges of rule of law in maritime Southeast Asia. And while my comments are going to come from my seat here in Southeast Asia, I think my perspectives are actually going to be most useful for extra-regional players. So I'll end with some recommendations for extra-regional players. So first, I would like to start by defining Southeast Asian security goals. And I think there's a lot of ways to look at that. but one place that really just struck out as a very succinct explanation from a fairly recent publication was our good friend and also RSIS alumni, Evan Laxmana, who last month in Foreign Policy explained that Southeast Asian security goals really boil down to three things. One, maintaining stability and legitimacy at home. Two, seeking strategic autonomy. And three, denying great powers hegemony over the region. And I think all three of those points, not only are they a good, succinct coverage of the overall security desires, but they also all three have direct reflections in the maritime space. So first, let's talk about what that maritime space is, for those of you that may not be paying close attention to geography. The real point of this map is not to show you the specific territories assigned to each country, or to debate whether or not each of those is accurate, but it's to point out that in Southeast Asia maritime space, almost all of the waters, in fact, all of the waters fall under some sort of national jurisdiction for rights or responsibilities. This is particularly important for extra-regionals who think that there might be a lot of space for international anti-piracy operations, et cetera. But the point is that wherever you are in Southeast Asian waters, you're in waters where some sovereign nation has some level of rights and responsibilities. Some of that may be disputed, some of that may be jointly managed, but there's no place that is fully out in the high seas. So the stability and legitimacy at sea in the region, this is, of Evan's 3 points, number one. What is it that states want in terms of stability and legitimacy at sea? Well, they want to be able to govern the space in a way that allows their national economies to prosper, allows their state governments to remain legitimate, and they can promote the welfare of their coastal communities. Unfortunately, there are a ton of challenges to that in the region. Those would include illegal, unreported, and unregulated fishing, sea robbery, terrorism, smuggling, ferry accidents, environmental harm, natural disasters. All of those things can essentially be prevented by good governance, which is the ability to make laws and then enforce the laws. Even the ferry accidents, these are a security concern in that an average of about 100 people a year die in ferry accidents in Southeast Asia. And if there was better regulation of the ferry industry and there was better safety inspections, those would probably go away. And so they kind of gets baked into the background as the terrorism issues and the piracy issues ebb and flow, and as increasingly there's focus on IU fishing. But the point is that there's a huge variety of safety and non-state threats, all of which undermine stability and legitimacy of the states. And this is, again, one of their top priorities. So this is an infographic from the State of Southeast Asia 2020. Throughout this presentation, I cut and pasted a few slides from either the 2020 book or the 2021 book. If I did use 2020 instead of 2021, it's because ICES did not ask the same questions in the 2 years. Wherever they asked the same questions, I took the newer data. Those of you guys that are familiar with this poll, it's not perfect data. You can't look at this poll and say, aha, this is what Southeast Asia feels. It's a voluntary response. A lot of the people questioned are policymakers, but many also are academics. So that tends to skew results. At the same time, you want to see a general trend of how security thought leaders in Southeast Asia are thinking. It's a good reference to understand about where the thinking is. And so I just note here that in 2020, if you take a look at what the top regional security priorities were, increased military tensions was among them, but it was not alone among them. Not climate change and domestic political instability, terrorism, et cetera, were also very high levels of concern. So at sea, this reflects back to the questions I was just talking about, those environmental safety and non-state actor threats to state security and human security at sea. So the other issues are more international relations in nature. They are threats to strategic autonomy and the advance of extra-regional states' hegemony in Southeast Asia. And here I think the point would be that the PRC is the state which poses the most concern. This is because the PRC has clearly disrespected rule of law. It's taken actions which are harmful to regional security. It's taken actions which are not in compliance with international law, and when called out at it, even formally, it essentially avoids any responsibility. Now, the point is, though, I would say that despite this ability and despite the strength of China, it has been deterred. It has been restrained in some ways by the prospects of either being too far discredited in the international world, or through the prospects of actual military confrontation. And so, when deterred, when regional states show strength, it shifts its contacts into the gray zone. And the gray zone would be areas where it has some sort of plausible deniability that what it's doing is not necessarily bad for the region. And more importantly, and more specifically, it's actions which remain under the threshold, which will cause an armed response. And these gray zone tactics work best when maritime governance is poor. If states in the region have ability to enforce their laws, then the amount of space in the gray zone is reduced. But instead, they take advantage of things like poor maritime domain awareness, poor abilities to enforce laws against fishermen, which could be, and those fishing vessels could carry maritime militia on board or otherwise be acting on behalf of the state. So this is a big issue, and this is an issue where the PRC is exploiting poor governance. The same seams that showed us these problems about state legitimacy at sea, in order to advance their hegemony in the region. But I think it's important to note that the PRC is not the only threat. There's also inter-ASEAN contests. You can see conflicts between fishermen in the region, et cetera. And you know that there are states with disputed boundaries in the region. And there's a lack of trust in the United States. And here I point out that Japan is the most trusted extra-regional partner. And I think that's an important takeaway for those outside the region who want to build a strategy of how to improve regional governance. I have a few slides here that are going to show some of the graphics from the 2021 report that help illustrate some of these dynamics. So first, trust perceptions toward extra-regional partners. The report had five countries it considered. And you can see green is good, green is confidence, and that there's high confidence in Japan, moderate confidence in the US and the EU, and the confidence in China and India not so high. Now, I also will point out, we'll see in a second that I'll just go to the next slide. A little bit slower and a little bit harder to show, but this is showing both the left picture is showing perception of trust. The right is showing mistrust, and then it's showing how it's changed over 3 years. And you can see that over the 3 years, it's relatively consistent, except for the United States. And in 2021, the changeover from the Trump regime or the Trump presidency to the Biden presidency made a huge difference in terms of the respondents' views on trust and distrust in the United States. Now, the point here that I would like to I think the important takeaway here is not, oh, the U.S. has an opportunity to move, or the United States really is trusted. It was just an anomaly that Trump was around for a few years. I think the point would be that domestic instability in the United States is going to be a cause for radical, an inconsistency in trust in the United States. And so, therefore, if you're an extra-regional power and you're looking to build a strategy, on the political side and on the trust side, it may not be best to hitch all your wagons to the United States, who's going to have another election in just 3 years. And you're going to see some sort of shift here in these numbers, regardless of how that election goes. So I thought this extra graphic was pretty interesting. Preferred responses to the South China Sea situation. The overwhelming number of respondents focused their desired in the South China Sea is to see a more principled stance that upholds international law, including UNCLOS and the respect for the 2016 arbitral tribunal's ratings or ruling. So the desire here is to see states stand up for international law, stand up for governance, stand up for rule of law that applies to states as well. So this is basically a reflection of the argument that China is not respecting rule of law, and if states could bind together to encourage that, that would be the best response, the preferred response to the South China Sea situation. And then I think this is my last slide, or my last graphic, I should say, and that is, who do you have the strongest confidence to provide leadership to maintain rules-based order and uphold international law? And so interestingly here, the United States shines out as the strongest. It's in competition with the European Union. And I think, for Japan, what's really interesting here is that while Japan is the most trusted partner, there's not a lot of confidence in them to lead in terms of rules-based maritime order. And I think the dichotomy is that while the United States is generally not trusted to do strategically the right things for the benefit of Southeast Asia, they are trusted to stand up for rule of law, and they do have sort of the military backing to enforce that. Whereas Japan has taken a stance where it's very much focused on economic development to the region, moved into support for law enforcement. And while that's very much appreciated and is an overall strategic picture, they're not seen as the solution, the country which is going to that's going to stand up for rule of law directly. And so this takes us to a space where would ASEAN like to move its strategic options? And you can see that it's focused on the European Union and Japan as new players, as third parties that would help hedge against uncertainties in the US-Japan strategic rivalry. I think in both of these cases, the ASEAN states are very concerned about the issues at sea and the competition more generally, and they're looking for a third party. And it's Japan and the European Union, which are seen as most keen to support ASEAN interests, and also those states which are most capable of making a difference without necessarily dragging ASEAN directly into the two-party US-China strategic rivalry, also known as great power competition. So we take that away, what would sort of my recommendations be very generally to extra-regional powers? One is to very much be involved in strengthening maritime governance in the region. I think this is important because if you strengthen maritime governance, as opposed to, you address all three security concerns. You enable states to keep their seas safe, and by keeping them safe, allowing them to be a source of economic prosperity, allow them to assist the local communities, the coastal communities, in becoming more comfortable and more secure, and that provides sort of strategic desire number one of the states. It also, perhaps a bit more indirectly, but it also directly supports the opportunity to stand up against external pushes on external hegemony and use of gray zone tactics to undermine the legitimacy of states and their rights and responsibilities at sea. So I think that strengthening maritime governance, these are some specific kind of steps to take to do that. One is to maintain the current level of emphasis on military. And what really I'm saying here is that military options are important. Military engagement by the United States is essential. The growing advances of military engagement by Japan and European Union states and Australia is welcome, but it's probably not helpful to take that too far, because if anyone takes that expands that extremely, they're not really getting at maritime governance, and they're exasperating the strategic competition. I think this is particularly true for Japan and European Union states, which are United States allies, yet right now have been maintained enough strategic autonomy in the region that they're seen as a viable third option. If they become too involved militarily, especially if they're seen as doing it with the United States, extreme example would be a bilateral allied FONOP, then they would no longer be seen as much as a third option, and it would degrade their abilities to flexibly work with the ASEAN states. The next point I would talk about is expanding maritime security governance capacity. That should actually say capacity building. Sorry for the typo. I think all extra-regional powers should work directly with states to expand their ability to provide good governance at sea. And that could include things like strengthening, laws and workshops ashore for empowering court systems and making for better legislation, but it's also enforcement capability. And what this does is it addresses the region's top maritime security priorities while de-emphasizing the sort of security dilemmas associated with going straight into military competition. I think in order to do that, it's important to empower civilian agencies in the lead. And that's both as the sort of recipient donors, but also the external supporters. The more it's a Ministry of Defense or a Department of Defense getting involved with improving maritime security governance capacity, the more that exasperates security dilemmas and more it doesn't exactly reach the desired audiences in the region. So even when a Navy may be the state's primary law enforcement at sea law enforcement organization, as much as possible that assistance or that cooperation can come from extra-regional civilian agencies would be beneficial. And then maritime domain awareness. I think most states have really understood this. It's a great place to be focused because it's actually an essential tool to maritime governance. It's a highly fungible capability, and it empowers not only better information to conduct operations, but better information to make strategic decisions. And I think that's an exceptionally valuable area. And then finally, I think working with partners to gain efficiency. This is sort of well known and well discussed that the more extra-regional partners can cooperate, the more efficient they can be, the more synergies can be gained. But I think it's important to not simply say, okay, cooperate, find a way to do this, but we need to be smart about it. You need to take a look at what different countries' strengths and weaknesses are, both in terms of what capacities they can bring, what experience they have in sort of training and development, but also how they're strategically viewed in the region, and make smart decisions about how and which partners should come together for what purposes. So just sort of some like finer tune on that. I think that Japan would be a great country to take a leadership within the Quad on maritime governance activities. So I pointed out they're the most trusted partner. They're also the most experienced and have the deepest roots in terms of developing maritime law enforcement and maritime infrastructure in the region. I think that expanded coordination with the EU would be welcome on all fronts, and that would include on the military, with the caveat that we don't want to go too far on that, on law enforcement, on governance, and also on infrastructure. But then ultimately, infrastructure investments should be coordinated as broadly as possible because they're just so expensive. And even the United States, rivaling China for the largest economy in the world, even Japan, which has an economy twice the size of the UK's, or is number 3 by a wide margin. Let's put it that way. Even either of those alone, or even in combination, are unlikely to make the kind of huge infrastructure investments that are going to move the strategic needle, or that Southeast Asia really needs. So continuing cooperation with other wealthy states, India, the G7 members, Australia, would be very smart. And with that, I'll wrap it up and turn it over to the next speaker. Thank you.
Thank you very much, John. I'd like to remind the audience, we finally have our first question in the Q&A. We're going to hold all questions till all 3 speakers have completed their presentations. But please feel free now, if you have questions to John, please put them in the question and answer. We'll come back to them after the first speaker. After all 3 speakers are completed. I'd now like to invite the second speaker, who's going to look at the issues through the eyes of as an international lawyer, Professor Makoto Seta from Japan. Please go ahead.
Thank you, Professor Beckman. So good morning. My name is Makoto Seta. So before starting my presentation, I would like to extend my sincere gratitude to RSIS and the Embassy of Japan in Singapore to give me the opportunity to speak this exciting webinar. And I thank all the participants. So let me share my screen. Okay, so now can you see my slides? Okay, So I'm an associate professor of international law at Yokohama City University. And do you know Yokohama City? So I'm a little bit surprised yesterday because John knows Yokohama City quite well. So last year, Yokohama Port might be notorious as a port where Diamond Princess was calling at. So Diamond Princess is a cruise vessel in which COVID-19 spread. So actually, Yokohama City is a good port city with many sightseeing spots like Singapore. So if you have an opportunity to come to Japan after this pandemic is over, so please visit and enjoy the city. And this is Yoshi, so mascot character of my university. So some of you might have the Japanese image as such a cute character. So the title of my presentation is The Dual Rule of Law for Ocean Governance, Recent Chinese Practices. So this is the content. So after the introduction, I will explain what I mean by the title, so the dual rule of law. And then I examine the recent Chinese legislation. And finally, I make a conclusion. Today's focus is the Indo-Pacific region, which mostly consists of the maritime area and not lands, as this map shows. So of course, those maritime areas are important for acquiring natural resources, both living and non-living. But at the same time, it is important as a shipping lane. So the order and stability of this region are quite important for states, especially for states which heavily rely on trade, including Japan and Singapore. However, recently, the region has unstable, and one of the possible reasons is few maritime delimitation in the region. So namely in the Asia-Pacific region, multiple states claim for the same maritime area. As you know, the South China Sea is a typical example. So in order to stabilize a region under such circumstances, the rule of international law is essential. I know that the concept of the rule of law has multiple understandings, and probably it can differ from societies to society. So its implication vary in the Japanese society, Singapore society, and the international society. So that being said, I assume there is a shared point that rule of law is an opposite idea of the rule of man or the rule of power. So under the name of the international rule of law, states are expected to comply with international law, so namely treaty and customary international law. Also, states are needed to follow the decisions of international courts and tribunals. And in the domestic society, so not states, so private individuals are expected to follow the laws and regulation. And states' organs need to enforce domestic laws and regulation in accordance with domestic law. And what I want to emphasize the fact that both of them are not separated. Since states shall comply with international law, domestic law must be compatible with international law. Also, when rules of international law do not exist or are vague, domestic law would contribute to the establishment and the clarification of rules of international law. So next, I want to move to the incident which often happen in the Asian Ocean, especially in the East and South China Sea. Since China and its neighboring states have overlapping claims, so their maritime law enforcement organizations often face their counterparts. So like this picture. So this is the picture taken at the maritime areas surrounding the Senkaku Islands. The left small boat is a Japanese fishing vessel, and the right big vessel is a Chinese Coast Guard vessel. The Chinese Coast Guard CCG vessel tries to police the Japanese fishing vessel, which engages in unlawful fishing from a Chinese law perspective, but lawful fishing from a Japanese law perspective. So the Japanese Coast Guard vessel tries to interfere with the police activities by the Chinese Coast Guard CCG in this way. But both the Japanese and Chinese Coast Guard usually do not take any measures against each other so far. So why? The answer is probably thanks to international law. So I will explain in detail. So what I want to highlight the fact that many rules of international law are applied to maritime law enforcement organizations. The picture at the center, this picture is the vessel named Reimei, the largest vessel of the Japanese Coast Guard, JCG. JCG plays a central role to enforce Japanese law at the ocean. Traditionally and historically, such law enforcement activities were not regulated by international law because such activities are the very center of sovereign functions. However, now, so many rules of international law are applied when state agencies such as the Coast Guard engage in law enforcement activities at the ocean. So since coastal states have different authority over different maritime zones like territorial water, EEZ, so these rules of maritime boundaries are essential. Also, in the undelimited maritime area, where more than 2 states claim their position as a coastal states of special obligation. Furthermore, the Coast Guard agency needs to comply with maritime police law and human rights law. Moreover, when the Coast Guard agency uses firearms, they must be careful not to violate the principle to prohibit the use of force. And when public vessels of other states are involved, the rules of sovereign immunity are essential. So this rule of sovereign immunity means a sovereign state cannot exercise jurisdiction over another sovereign state. And this exercising jurisdiction includes police activities. So more concretely, states Coast Guard cannot police each other. So as I showed in the previous slides, Japanese and Chinese Coast Guard confront each other, but they do not police each other. Probably one of the main reasons is that they know if they police, it would constitute a violation of this sovereign immunity. In this context, China enacts 2 controversial legislation in this year, so I will examine one by one. The first one is New Chinese Coast Guard Act, so which entered into force on 1st February this year. So this CCG Act was established to provide CCG with a legal foundation and guideline of law enforcement activities. So this act is administrative and procedural in nature. And as far as I understand, it strengthens the CCG's military character. This act is supposed to be applied to the China's jurisdictional water according to its Article 3. However, the meaning of jurisdictional water is unclear. So probably this water includes the South China Sea, to which China claims its sovereignty. And when I look closely at this new CCG Act, I find it would violate international law. I personally do not consider the enactment of this new law itself violates international law because we are not sure what jurisdictional water means, for example. So if China applies this act only to its territorial water, it might not violate international law. Whether states violate international law or not mostly depends on its domestic law application and not on enactment itself. However, I have to say that some provisions of this new act would be a cause of future Chinese violation of international law. I listed 2 consecutive articles, Articles 20 and Article 21. Article 20 provides that CCG remove the facilities built by foreign organizations and individuals in China's jurisdictional waters. If this foreign organization includes foreign government, and this act is applied to the South China Sea, the application of this act will be a violation of the UNCLOS. So this is because this article enables China to remove facilities built by the Philippine government in the Filipino waters, because China still maintains its position that most parts of the South China Sea belong to it, even after the tribunal rendered that the Chinese claim of 9-dash line is invalid under the current international legal framework in 2016. So next, Article 21. So Article 21 stipulates CCG has a right to take measures such as deportation and forced towing even against foreign warship and government ships when they violate Chinese law and do not follow the instruction. This act manifestly says that CCG will take some enforcement measures even against foreign warships as well as government ships. So if this provision is actually applied as it says, it is highly likely to constitute a violation of immunity enjoyed by other states' public vessels. The second legislation is Revised Maritime Traffic Safety Act, MTSA, so which entered into force on 1st September 2021, so quite recently. So this act was established to strengthen maritime traffic management and safeguard Chinese rights and interests. Unlike CCG Act, this act is more substantive in nature, but this act is also applied to China's jurisdictional water, which is also unclear. One of the biggest differences between CCG Act and MTSA is Article 121 of the MTSA, which says that when MTSA provisions are not compatible with international treaty ratified by China, the international treaty shall prevail to MTSA rules. So this rule looks to try to harmonize Chinese domestic law with international law. So this is a big difference from the new CCG Act. So that being said, some provisions might violate international law. For example, Article 54, which requests foreign vessel a prior notification when entering the Chinese territorial waters, would violate the right of innocent passage provided in Section 3 of Part 2 of the UNCLOS. Also, though its meaning is unclear, Article 120 might violate the rules of sovereign immunity because this article said that both government vessel and military vessel of foreign state are also subject to the Chinese domestic law. Okay, so this slide shows my thoughts on the two legislation. So one of the serious problems of the GS legislation is that some provisions of the two acts solely target foreign organizations, individuals, and vessels, and not domestic national ones. So they seem to have a military or security character rather than law enforcement character. As for the question on to what extent the new CCG Act and MTSA have been applied since their enactment, to be honest, I'm not sure. But as far as I understand, although half a year has passed since the enactment of the new CCG Act, the behavior of the CCG has not dramatically changed. So lastly, it is true that the enactment of this domestic law itself constitutes a violation of international law. So some provisions like Article 54 of the MTSA would violate international law because its promulgation would affect the navigation route of the relevant vessels. But as for most rules, whether they violate international law or not depends on the interpretation and application of such rules, as I explained. So we have to wait and see the Chinese interpretation and application of this law. Conclusion. So this is a quotation of article written by Professor Raul P. Pedrosa, an expert of the law of the sea at US Naval War College. After the MTSA was revised, he argued that so China is once again testing the international community to gauge how it will react to the enactment of yet another maritime law that exceed the permissible jurisdictional limits of international law as reflected in UNCLOS. China will undoubtedly use the new law to engage in gray zone operations below the threshold of armed conflict to intimidate its neighbors and further erode the rule of law at sea in the Indo-Pacific region. So I agree with his conclusion. So then how should we respond to such Chinese policy? So my answer is that differentiating the Chinese understanding from the common understanding of rules of international law, if possible. And for that purpose, so actually Chinese domestic legislations, so including the legislation which I introduced, is very important, and they can be a key to perceive the Chinese understanding. Also, to foster the common understanding of rules of international law, I can propose two methods. So they are not new at all, but still resilient and reliable. So first, recourse to international courts and tribunals. If all states accept the authority of such courts and tribunals and follow their decisions, common understanding is strengthened. Actually, after the UNCLOS entered into force and the UNCLOS Tribunal started their own works, the number of international litigation on the law of the sea has dramatically increased. Moreover, last year, so Singapore and ITROS, International Tribunal for the Law of the Sea, signed model agreement to enable the tribunal sit in Singapore, so Asian states can bring the dispute before ITROS in Singapore more easily. So second, public discourse and dialogue at the global level. I hope this webinar can be a part of such discourse. So, but more effective one is state-to-state communication. I would like to introduce the reactions by states against a submission by Malaysia to the Commission on Limits of the Continental Shelf, on the outer limits of the continental shelf in the South China Sea. So China harshly criticized Malaysian submission because Malaysia claim overlaps Chinese claiming area. So, but these Chinese statements have been also harshly criticized by many states like Philippines, Vietnam, Indonesia, and no ASEAN states like the United States, Australia, France, Germany followed, and Japan also echoed. Although it takes a time to change the attitude of states, but it is essential to share the common understanding of international legal rules and persistently disperse such understanding. So this is the end of my presentation. So if we have a Q&A time, so I would like to exchange views with you. So thank you for your attention. ありがとうございました。
Thank you very much, Professor Seta. Again, I remind everybody we will take questions or respond to questions at the end of all three speakers. Please put your questions in the Q&A. I note there are 3 questions from the first speaker. I would hopefully we'll get some questions to Professor Seta as well. Okay, we now move to our final speaker, who is looking at the issue from a public policy perspective, especially from the perspective of Japan and their public policy for the region. Professor Benjamin, go ahead.
Okay, so good morning, everyone. I hope you can hear me. So thank you very much once again to our hosts, RSIS, and to the Japanese Embassy in Singapore. And of course, my co-panelists, Bradford Sensei and Seta Sensei. Okay, so I think it's a very good mix of our panel. We have a very good mix of our panel. So Mr. Bradford talked about the maritime governance issues from a perspective of security. And then Professor Seta talked about the rule of international law. So in my case, I won't be looking too much on the major powers, but rather what is actually happening or how it's being interpreted or understood by the smaller powers, in this case, the Philippines. So allow me to share my screen. Okay. Okay, so okay, so the title of my paper is The Missing Link of Rules-Based Order, Japan as a Hedging Power and Its Public Diplomacy in the Philippines. Okay, so it's something like this, the reason why I started this initial paper is really how it's being perceived here in the Philippines, the PCA arbitration ruling. So by 2016, you're familiar with what happened. The Philippines won the arbitration. We were so happy. And then we have this new president, President Duterte, who promised to even personally ride a jet ski and go to the Spratly Islands and plant the Philippine flag. And then what happened a few months after the declaration of the winning of the arbitration? Come. Basically, you have an about face between the Philippines going towards China. So for the average Filipino, the question is, why? What is the reason behind this? Why is America such an untrustworthy partner? And why can't we just go to the UN and the ASEAN? Of course, for us, the informed public, and for us specialists in diplomatic affairs, we are aware of the answers. But how is it really perceived in the public? So that's what I want to do for my paper. So I'll be focusing on 3 topics. So how the PCA award is perceived and understood in the Philippines. Japan is now seen as a counterbalance and hedging power in the region and in the Philippines. And then a quick review of its diplomatic activities. Okay, so I mentioned it a while ago, the context, I think we're very familiar with this. You have the free and open Indo-Pacific, the ongoing South China Sea disputes, and then the prospects of the code of conduct in the South China Sea, no, which is still being discussed, and the prospects seem to be not so good. No? And then we are again aware of what happened with the bandwagoning of Duterte towards China, wherein we are now pursuing an independent foreign policy. So how is my paper different from other papers or other studies? No, I'd like to look into something that's not as discussed as much, which is public diplomacy. No, so when we talk about Japanese public diplomacy, we all know about Cool Japan, its tourism, its infrastructure, peace diplomacy, and even human security, and the importance of messaging and branding. But again, why public diplomacy? No, so I would like to show that even though public policy and political elites might be impressed by Japan, public opinion and the informed audience do play a role in policy making, especially now that we are going into an election year. No? And of course, while security management, hard power diplomacy really plays a role, states cannot really forego or afford to forego public diplomacy. So what are some of my main arguments? No, I have 3 points. In the context of Duterte's rhetoric against the US and its abandonment and shift towards China, the Philippines is now seeing Japan as an equibalence or hedging partner against China. While Japan has been successful in its diplomatic efforts, especially in this upcoming election year, no, Japanese diplomacy, public diplomacy, should have a more cohesive message directed towards policy elites and public intellectuals. And then, now that we know all of these, no, Japan now plays a central role, should play a bigger role in the free and Indo-Pacific policies and show that it is in fact a reliable partner that could balance against China. So, what are now some of my the contents of my presentation? Again, we've done their introduction. We'll go to discuss the PCA award. We're going to discuss Japan's public diplomacy in the Philippines, and then the prospects of public diplomacy in the Philippines and in the region in general. Okay, so let me now continue to my presentation. Okay, so again, we've already discussed the PCA, no? So you're probably aware of it. No, so it basically said in July 12, 2016, that the 9-dash line is contrary to UNCLOS, that the convention supersedes historical rights, which is the main basis of China's claims. And then China has breached Articles 60 and 80 of the convention when we talk about sovereign EEZ. No? So it's basically a victory. No? So, and we all know what happened next. The Philippines did an about face, no, from going against China towards a more balancing, a bandwagoning act. No? So what happened as Duterte started his administration? We have an increase of anti-US rhetoric. No? So in the lower left picture, he's showing pictures or printout of some of the atrocities during the American occupation, no, during the early 1900s. And then he talks about how America is the #1 terrorist and blah, blah, blah. Well, we know who Duterte is. And then afterwards, the Department of Foreign Affairs mentioned that it's now pursuing an independent foreign policy. So what is an independent foreign policy? It's actually a trend, no? From the previous administration during the Arroyo period, it was equibalancing. No? So it was in the middle of everyone. No? So distancing a bit with the US, going closer to China. And then, of course, during the Aquino administration, during the PCA period, Aquino was really balancing, going towards the US and its allies, which is Japan. And then during the Duterte administration, it was again a bit of bandwagoning and equibalancing. No? And then during this context, no, so we still have the usual South China Sea disputes, the maritime issues that Mr. Bradford mentioned. For example, in 2019, there was a maritime incident between Filipino fishing boats and the Chinese Coast Guard. So again, no, so there was a mixed messaging at first they were saying that no, it's really China's who has fault, etc. And then later on, the Philippines backtracked due to Chinese pressure. Okay, so how did Japan react to all of these happenings? Actually, Japan was very astute. Instead of panicking that, oh no, the Philippines is one of our strongest partners as a balancing against China, Japan actually didn't overreact. In fact, what did it do? It actually increased its charm offensive. So Prime Minister Abe, as you can see in the picture, visited the home of President Duterte in Davao. There they are having breakfast, and then there they are having durian. No, and then in spite of the rhetoric against the U.S., what did Duterte emphasize? That Japan is actually a true friend, closer than a brother. No, and then they were talking about how Japan is committed to Mindanao to bring peace diplomacy. It's actually a good competition partner when we talk about infrastructure development, and even for policy elites and policy makers, they saw Japan as a strategic hedge. No, it's the bulwark and safeguard against China and U.S. abandonment. So we can really see that Japan actually made a very astute and very good decision in its diplomacy. So after discussing all of these things, now let's look into the specific diplomacy that Japan has been doing from before the Duterte administration and until now. No? Okay, so for three aspects, the first one is security arrangements. I think we're all familiar with this. You have the rule of law and freedom of navigation. Japan has been constantly doing visiting forces agreements with Japan and in the Philippines. You have military exercise between the Marine Self-Defense Forces and the Philippine Navy. We have a memorandum of agreement between the Ministry of Defense and the Department of National Defense. And then, of course, Japan has been giving ODA by giving patrol ships the Philippine Coast Guard and surveillance planes. So under ODA, it's used for security apparatus, no? For security governance. Okay, now let's go to the other aspects of Japanese diplomacy in the Philippines. The next one is, of course, peace building in Mindanao. Now, we already know, and it was discussed a while ago by Professor John, that Japan is not seen as a strategic partner. So, since they are not a strategic partner because of the limitations of its constitution and its foreign policy, how do they actually pull its weight other than economic power? It's actually through peace building. No, Japan has been successful in arranging the peace building operations in Aceh, for example. So they now want to make Mindanao as the showcase of Japanese peace building. And if the model works, then they could do the same thing for the other regions and the other countries such as Myanmar, Thailand, etc. No? And as you can see in the map, you have all of these projects, whether it's on development, infrastructure, and they really play the role in the creation of the autonomous region in Muslim Mindanao. No? So the Bangsamoro Initiative, or JBIRD. So again, you've already ticked the box of security. It's seen as a very viable and respectable partner in Mindanao. So the third one is, of course, infrastructure. Everyone loves infrastructure. No? And what's interesting is, while President Duterte talks about how China, we cannot fight with China, and China is promising to build infrastructure, China hasn't actually delivered on its promises. And even the Minister of Foreign Affairs in the Philippines is saying that, no, it's actually Japan who's trustworthy. No, it goes hand in hand with Duterte's build infrastructure, and through the help of JICA and the Ministry of Foreign Affairs in Japan, you can see all of these developments, no, in Metro Manila, in Cebu, and even in Mindanao. So Japan has been ticking all of the three boxes. So it's a worthy partner. Everyone trusts Japan. Everyone loves Japan. And yet, it seemed to be very different when we talk about international affairs. So this is what I want to talk about in the fourth part. No? What is actually the prospects, or why are the perceptions of Japanese powers such in this way? No? Again, this is just initial data. No, I'd still like to look into it and try to build on my arguments, but let me show some interesting facts and information. Okay, so again, what is public diplomacy? Public diplomacy is very simple. No, when we talk about diplomacy, it's state to state, Japan and the Philippines, Japan and ASEAN. No, but what is public diplomacy? It's basically state to the people. No, it's about sending your message across. It's the battle for hearts. No, and while, for example, we talk about international law, we talk about maritime security, but if it doesn't filter towards the public intellectuals and then the electorate in general, then you will have limitations. And that's actually the role of public diplomacy. We want to target policy elites, public intellectuals, and an informed public. So what is now some of the initial findings or some of the takeaways that we can see when we talk about Japanese public diplomacy. I'd like to cite the ASEANs State of Southeast Asia that Mr. Bradford showed a while ago. And just like what he mentioned, it's not a general poll. It's actually directed towards the academe and government. No? But it also shows what the directed and informed public actually thinks about Japan. Okay, so let's go over some of the slides. Okay, so is Japan a strategic partner? Mr. Bradford showed this a while ago. No, it's not seen as a strategic partner. In the Philippines, it's only 4.5%, and in the average in ASEAN, it's only 10%. No? And which regional organization has the most strategic influence in Asia? Again, Philippines doesn't see Japan as a strong strategic partner, and ASEAN in general doesn't see Japan a strategic partner. So what is this duality? How come Japan is not seen as a strategic partner, but it's well trusted? No, Mr. Bradford mentioned it a while ago, so let me just show some more slides. No, what I think is it shows Japan as a potential strategic partner. If we can see, for example, if we do not trust the US, who is the one that could be the strategic partner? In the Philippines, it's bar none, Japan, 50%. Okay. Are you confident that Japan will do the right thing? No. And in the Philippines, it's 58%, the highest one, more than the EU or America. It's actually Japan. Okay. So again, going back to this issue of strategic influence versus trust rating, I think this is the most telling slide. No. You can see that Japan is seen as a respectable stakeholder in international law. That's 44%. Japan has plenty of economic resources, 25%. But then when we talk about political culture, it's only 4.3 or 3.7%. I think this is what's important when we talk about public diplomacy. When we want to win the hearts and minds, it's not enough that we provide global economic leadership. It's not enough that we provide guidance when we talk about maritime security. We have to win the hearts and minds and the branding. So we have to show that we are on the same values and worldview. And this is, I think, where Japan is lacking. No? And it's really more about branding. Okay, so when we talk about public diplomacy, again, I'd like to emphasize 3 points. One are the initiatives. The second one is what are the policy outcomes. And last is messaging and branding. And from what I see, perhaps it's really a matter of having a central brand and a central message. Of course, Japan talks about human security, talks about free and open Indo-Pacific, but what does it actually mean on the ground? This is something that Japan has to think about. Okay, so let me end my talk by going over some of my closing remarks. Again, Japan is now seen as an equibalence and hedging partner. It's clear to us. We already see the role and the impact of Japanese diplomatic efforts in the Philippines, but I think Japan still needs a stronger message, whether it's not just in the Philippines, but ASEAN in general. And I think central to that messaging should be that Japan is actually playing a central role in the free and open Indo-Pacific. And they are actually reliable regional partners in the economic, political, and even in the values and norm front. So Japan should go about and go straight on it, attack the issue head on. So they should say that we are indeed a balancing power against China. So that's about it. So I'd like to hear your comments and suggestions. And of course, I'm looking forward to our discussion. Thank you very much.
Okay, thank you. Thank you very much. We have some questions in the floor, but perhaps I could begin with a couple of questions, maybe in the prerogative of the chair. I think the common themes we've seen is that China is a threat to rule of law in the region. Japan is the most trusted by ASEAN and should play a greater role. True, and the question is whether that role should be through military assistance or capacity building, as well as greater public diplomacy. I guess I have two questions. One would be, can we be a little more precise as to what rule of law we're talking about? Because even Professor Seta did not mention the 2016 arbitral award, and I think John didn't mention it either. So exactly what are we talking about in terms of rule of law, and what could Japan do about that? How could Japan actually counter the perception that China is breaching international law, given that there may be some restraints on Japan because it has bilateral issues with China in the Senkaku. So I'd like some views on that. Maybe we could talk about that first, and then we'll move to the questions in the Q&A. Any order you like on this? John, you want to take off on it?
Sure. Yeah, I think that being non-lawyers, both San Jose and I mentioned the arbitral ruling, but we didn't spend much time on it. I think that the Chinese violation of rule of law comes down to the fact that the central point of rule of law is that there is international law and that states acknowledge that they have to follow it and that they elect to follow it. And that electing to follow it should not be necessarily have to be enforced by military conflict. And thus far, China in many areas, including the South China Sea, has essentially taken the attitude that, well, if I can get away with doing something without starting a war, then I'll do it. And I'll claim the law doesn't apply, or I'll pretend that I'm following it, or I'll otherwise obscure the facts. So I think, if I can be very blunt about it, that is what China is doing to violate rule of law. I think there are other states, as I pointed out, that also from time to time don't follow the law in all ways. But in this region and in this maritime space, China is perceived as the greatest culprit and therefore the greatest threat. As to what Japan should do about it, my central point is that they should assist with regional states being able to, there should be a dual front attachment. One is, as Japan has done, it should continue to take a strong diplomatic stance. It should support international institutions that support rule of law. But then specifically with the Southeast Asian countries, it should help them with their governance capacity. And that could include a wide range of activities that I mentioned. Next.
Okay.
Here I go.
Prof. Seta, or you want to go ahead and make some comments?
Yeah, I will make some comments. Okay, so thank you. So thank you for your question. So as for the 2016 decision of the arbitral tribunal, I think Japan strengthens the kind of importance of that decision. So as an expert of the law of the sea, I have the impression that many rules of international law of the sea are vague and unclear. So sometimes the understanding can be different from state to state. But what states should do is to respect the decision of international courts and tribunals, because once all member states to the UNCLOS give such kind of authority, so including China, so China also gives such authority to international courts and tribunals when it ratifies the UNCLOS. So all the other states request China to comply with the decision of the arbitral tribunal. And actually, so Japanese government did so just immediately after the arbitral tribunal rendered the decision. And as I introduced in the discussion in the CLCS, Continental Shelf Commission, so actually China denied the kind of validity of the arbitral award, and other states said that it's valid. So China should comply with the decision of arbitral award. So without such a decision, so probably it would be more difficult for other states to say that China violates international law. But now they can just recourse to the kind of authoritative decision and just say that it easily criticize Chinese attitudes. So in that way, so Japan and other states should recourse to international decision of arbitral award. So this is my point. So thank you.
Okay. Allow me to just give a quick comment, Professor Beckman. So you mentioned a while ago, what actually do we talk about when we talk about rule of law? Now, at least for the Philippine case, it's really just a matter of enforcement. So we had the moral victory when we won the arbitration in 2016, but then afterwards the question is, what can we do? How can we enforce the law? No, so it's basically about maritime security more than anything else. No, you need hard power to do it. And in the Philippine case, since because of the restraints of Japan or the conditions of America and the geopolitics in the region, no one can really step up other than freedom of navigation operations. No? So in the Philippines, no, there's two camps. It's basically balance to America or bandwagon to China. And then, although I basically follow the idea of balancing to America, but then when you ask the policymakers in the Philippines, how do we balance with America? They just always say rule of law, rule of law, rule of law. They don't actually address the issues. So if you're very astute and pragmatic, then you really see the value of what geo-balancing does. No? And then another line of thinking, at least in Philippine policy circles, is the role of international organizations such as ASEAN, especially with the code of conduct that's being discussed a while ago. And in IR, this is what we call institutional balancing. No? We use ASEAN as an institution to balance so that we don't have to go or choose between the major powers. But as we know, because of the ASEAN setup, the ASEAN way, and then the weakness and the inherent limitations of ASEAN, then ASEAN can't actually be an institutional balance. No? So going back to your question, what can Japan do? I think Japan should just follow what has been doing. No? So concentrate on its infrastructure, competing in infrastructure and economic and even maritime security. But then probably if they just have a stronger message or a stronger narrative, no, maybe that would actually have a stronger impact, no, not only in the Philippines but also in the larger region. No, so how do you go about showing that? How do you brand yourself? No, that you are a viable partner in ASEAN. Maybe that's the interesting question that I'd like to explore. Thank you.
Okay, thank you very much. I'd like to now. I'll just read some of the questions in the question and answer. The first is from Maria Exmundo. Do you think the concept of ASEAN centrality in the third alternative to maintaining peace and stability in the region is still viable? That's a question she asked to John. Given now we have the new arrangement between Australia, US, and UK, you have the push of the Quad. To what extent are these really a threat to ASEAN centrality? John, you can take on, and anybody else wants to comment, you can.
Yeah, well, I mean, in terms of going back to the original topic, which is rule of law in Southeast Asia's maritime spaces, I think ASEAN is often not given the credit it deserves, and I think its centrality is central to that. In fact, ASEAN, it just has, in fact, slowed China's advance. It has installed reputational costs against China. And I guess an example of this would be how long it's taken, how long the negotiations over a code of conduct have taken, and the fact that they're still going on. Now, do we think that a code of conduct is going to solve things? I don't think so. And if you take a look at the IC's report, we've all been talking about, most strategic thinkers in the region don't think so either. But I think, the question is, if there were no ASEAN, what would it look like in the South China Sea now? How much stronger would China be? And I think the answer is that ASEAN has done quite a bit. That said, I think that it's not done enough, and it's continuing to lose power in that equation. So it's going to lose ability to keep things slow as times go by. And that's for two reasons. I think the power of the general power dynamic between China and ASEAN is steadily shifting towards China in those discussions. And ASEAN is becoming more and more divided on these issues, which will further weaken its position. So ASEAN centrality is central, and it's invaluable. But at the same time, I can understand perfectly, it's perfectly natural for both the regional and the extra-regional partners to look into other alternatives to prevent the outbreak of conflict in the region.
Okay, thank you. Are either of the other two speakers like to comment, or should we move to the, otherwise I'll move to the next question. Second question is from Dr. Salil Sen. Maritime domain constitutes what parameters? Military, environment, economic, nature. What is the future of maritime domain awareness given 2030 Sustainable Development Goals, which include conflict avoidance and giving peace a chance? So it's a rather complicated question. Maritime domain, how do we link it to the UN Sustainable Development Goals? Anybody want to comment on that?
I can do it briefly. It looks like others might be thinking of taking some notes. I mean, I think that this is a different way of framing the exact argument I was seeking to make in my presentation. The fundamental thing which is needed is development in the maritime space of Southeast Asia. And if we can develop those spaces such that people can legally and safely gain access to the resources and use the trade routes to benefit societies ashore, that is going to strengthen the socioeconomic framework of the ASEAN member states and the communities which live in this region. I think that will, also directly impede China's ability to continue to illegally take advantage of its neighbors. And so that's why much of my focus is on developing the space economically and improving governance. At the same time, I think military deterrence still has a role, and strengthening a situation where both sides are afraid to take action because the costs are too high is an important part of international stability.
Okay, thanks. I think that's good enough answer for that one. Next, we have a very provocative question. I think unfortunately, as an American, probably pointed toward John again. Under the Monroe Doctrine, the U.S. treats the Americas as its backyard. For example, Cuban Missile Crisis. Isn't China doing the same thing for East Asia? Implied doesn't have the same right.
Yeah, okay. So I think the analogy is imperfect, but let's assume it is perfect, and let's talk it through. So first of all, President Monroe was president in 1823, and the Monroe Doctrine was developed to describe the proto-imperialistic approach that he started. It was a shift in American diplomacy. So if we want to make the argument, or someone wants to make the argument that, hey, China is just imperialistic like the United States was 200 years ago, from a purely historical or righteousness ethical position, perhaps that's true. Now, I think the question is, does China want to have a proto-imperialistic policy and go down the path that the United States went through 200 years ago? I would say as an international world, I hope we've moved past that. We've certainly instituted things like the United Nations and legal mechanisms that say imperialism is something that we don't want to do anymore, and that we don't think it's best for the world. And so I think that in a purely sort of ethical position or a contest of ideas, it's not a very strong position for China to take. But if you leave all that aside and you say in your follow realpolitik, right makes might makes right kind of approach, and you see where it takes us, I think the history also plays out. The United States began down this path as a rising power, and the old powers didn't really like it. The United States didn't simply take over the Western Hemisphere, but it had to fight conflicts with European powers. Conflicts which were not really good for the United States. They weren't really good for Europe, and they certainly were not good for the battlefields, the people living on those battlefields. So I don't think that that's a particularly good path, and it eventually brings us to the, brings us the full circle through the age of industrial imperialism to the world wars. So, I don't think from any standpoint arguing, hey, someone else made a bad decision in the past, I can make it now, is a particularly useful stance to take.
Okay, thank you very much. Let's move on. And first question to Professor Seta. How can a community of nations collectively take China to an international court for violations of international law in its domestic law?
So thank you for your question. So actually, it's a kind of a limitation of the law, but after some incident happens, so some states can bring the case before the court. So for example, if Japanese Coast Guard is kind of arrested by the Chinese Coast Guard, so probably Japan can claim that the China violated sovereign immunity. so before international tribunal and the court. And especially in the case of UNCLOS, Part 15 of the UNCLOS provide the kind of a compulsory dispute settlement mechanism. So Japan can unilaterally bring the case as Philippines did in 2016 arbitral tribunal. And in terms of a collective one, so there are some options. The first one is to be a co-applicant. And of course, some requirements must be fulfilled, but in the case of the case concerning the interpretation of the jurisdiction of the ICAO. So it's now on the pending before ICJ. So Bahrain, Egypt, and United Arab Emirates is a kind of a co-applicant against Qatar. And second one is a kind of a participate as a third party. So this happened in the case between Australia and Japan for whaling. So Australia claimed that Japan violated whaling regulations. And actually New Zealand participated as a third party and basically supported Australia. So in this way, so suppose the situation that, okay, so Japanese Coast Guard are arrested by China and Japan brought the case, and Philippines, Vietnam, or other kind of a relevant state can participate as a third state, and they can uniformly claim that the Chinese new CCG Act, which infringes the sovereign immunity, consider violation of international law. So probably that is another situation. And the third one is a kind of a discussing before the litigation. So this happened in the case between Gambia and Myanmar. So as far as I understand, the victim of the Myanmar suspected genocide is Muslim. So Muslim state gather and consulted. So which state brings the case before the ICJ, and Gambia was selected. So that's why Gambia brought the case against Myanmar for genocide against Rohingya. So in this way, so there might be kind of a three options for states to collectively bring the case before international courts and tribunals. Thank you.
Yeah, I would just like to comment on that as an international lawyer as well. Again, there's been a lot of criticism of the Chinese Coast Guard law, but it was passed in February of 2020. I don't know of any cases yet where it's actually states have alleged that there have actually been violated in its application. And in terms of the new maritime transport law, that transport law does provide that the extent it's inconsistent with international law prevails. So, and that's a much more cautiously worded legislation. So I actually, looking at it yesterday, I didn't think that it's going to be much of a cause for concern, and some of its provisions may be greeted with sympathy from some states in the region. So I would just leave it at that. Next question from Santiago Castillo, who sends her regards to Professor Benjamin. Apparently was one of your students. The question is for the three speakers. Former Prime Minister Abe had his vision of Japan playing a more proactive role in international security issues, and this is likely to continue even after his administration. As it is developing further its defense capabilities, can Japan eventually be accepted as a leader of a rules-based order in addressing maritime security challenges in the region, particularly in East and Southeast Asia? Or will it continue to utilize security arrangements like the Quad and its alliance with the US to pursue a more proactive role? Anyone want to take that on?
Sure, I'll say something brief. I mean, the heart of the question is whether or not Japan would be in a position to stand up and become the champion of international law in the region alone or with partners. It says, you know, with those security arrangements such as the Quad or its alliance with the United States. I think the answer to that is quite simple, and then I would like to expand on a point. And the simple answer is no, I don't think Japan is going to become a unilateral power. It's going to continue to work with the US-Japan alliance, and it's going to continue to expand its partnerships such as the Quad. There's just no strategic rationale nor political domestic movement in Japan which would get it to become a unilateral actor. And you know, if it were, it would, while I have tremendous respect for the self-defense forces, and it is the third largest economy, it has a very long way to go to compete with the United States or China. So it wouldn't be very realistic. But I think, the sort of more interesting question is, what is that role and what should it be? And while I also have a tremendous amount of respect and confidence in Japan, I worry that a military posture could go too far. I am glad for the developments that they've made and that the alliances or the partnerships that they've developed. But right now, the strength of the Japanese position is that it's trusted and it's respected, and it is a third option. And if it becomes too militarily powerful, or it becomes too tied to the United States, then that power will diminish. So that's why, my recommendation to Japan would be more in alliance with what Professor San Jose has talked about, which is to develop its public diplomacy, develop its soft power, develop its civilian capacity building projects, while keeping its military posture. I don't know if he said this, but I'll say it. Well, keeping its military posture growing, but on a relatively slow trajectory as it has been.
Okay. Anybody else want to comment on that? Should I move to okay, Benjamin?
Yeah, I'm fine. Yeah, I just want to echo Bradford Sense's comments and ideas. It's basically that. No, I mean, unless there's a sudden shift in domestic politics, then it'll be the same. Okay.
Okay, thank you. Next question. Many people in ASEAN think that Japan is largely following the US position such that it's just a satellite of the US. Why is Japan willing to play such a role? I think that's directly on Professor San Jose's. You want to comment on that?
Well, I think this is just, again, touches to what Bradford Sense mentioned. No, it's basically Japan is constrained. No, so until we have a revision of the Constitution or another reinterpretation of the Constitution, then Japan really has no choice but to be partner of the Quad, for example. But whether Japan is actually a satellite of the US, that's debatable, and that's a different discussion all the more. Okay.
Well, let me touch on that other discussion that got alley-ooped for me so I can do the slam dunk. So first of all, while many people in ASEAN, I think it would be quite reasonable to think that Japan was a satellite of the United States. If you just looked at the facts, it seems that there's a lot of ways it seems that way. But the data that both San Jose and I showed in our presentations shows that a lot of strategic leaders in Southeast Asia don't feel that way. That's why there's a huge delta between the trust that is placed in Japan and the United States, and that's why Japan is often looked to as a viable third option. And I think that's valuable that Japan retains that.
Okay, thank you. We have 7 minutes left. I'm jumping to see which questions I think don't overlap with topics we've already covered. Like ask the following question. I would like to ask Professor Seta, how much is China's attempts to challenge the rule of law in the South China Sea the result of domestic pressure at home, whether influenced by nationalism or directed by insecure leaders? Or is it the result of assertiveness of individual military leaders rather than some kind of coherent grand strategy? How would an adherence to rule of law serve China's interests, both at home and abroad? Is China's current strategy a rational one, given domestic considerations and the potential payoff? Finally, separately, I'd like to ask Professor Benjamin if there are existing efforts for public diplomacy with Chinese. How about with regard to overseas Chinese in the Philippines or in other ASEAN countries, including those who have only recently migrated very long question, a lot of elements. Who would like to comment on some of it or all of it?
So may I answer the question, first question?
Well, first question is how much are China's attempts to challenge rule of law?
I will. Okay, so thank you for that question. So actually, I'm not a Chinese expert of the Chinese politics, so my knowledge is limited on that point, but I have the impression that the current Chinese leader is more aggressive than the other leaders. And so after he took a kind of initiative, so the kind of a more aggressive, Chinese aggressive attitude started, especially in the maritime domain. So if the leader would change in the future, the Chinese attitude might change. But as I said, I'm not that expert, so I'm not so sure. And so as for the benefit of a rule of law for China, is from the kind of a long-term perspective, it's quite obvious. So now China has a great economic power and so economically growing. So now it's a nice on the good condition. But in the future, if it becomes unstable, so probably the international trade or economic partnership will be more important. And for that aspect, so probably the same rule or respect for the rule is a kind of essential for strengthening the economic partnership. So now China is applying for it. It's widely broadcasted that China is also willing to be a part of the so-called TPP, Trans-Pacific Partnership Agreement. But so some Japanese experts are a little bit skeptical to what extent China would comply with rules of such kind of partnership. So in the long term, so I'm quite positive that respecting the rule of law would also be benefit for China. And with respect to the maritime domain, so if China show the kind of willing to comply with international laws, especially law of the sea, probably it would facilitate the kind of joint development between China and Japan, which was concluded in 2008. So in 2008, Japan and China successfully concluded a kind of agreement for joint development, but after that, so it was suspended. So if both states have kind of show the willingness to cooperate and also the respect rule of law, so probably that kind of joint development would be more easily facilitated. So this is my answer. So thank you for your question.
Okay, thank you. I think Benjamin, perhaps you can comment about to what extent China's policies seem to be targeting what we call overseas Chinese in Southeast Asia. Do you have any?
Thank you for the wonderful question. That's actually a very astute observation. No? So when we talk about public diplomacy, even when we talk about Japanese public diplomacy, usually we compare it with China, the China case. And China is very interesting. No? So what are some of the initiatives of China in the Philippines? Of course, vaccine diplomacy. No? So most of the Southeast Asian vaccines are actually from China. And then infrastructure has been always going on because of the Belt and Road Initiative. We all know that. But then even when we talk about the cultural realm and the education realm, China is actually very aggressive. We already know the presence of the various Confucius institutes in our countries, no? But regarding the question of whether China is actually reaching out towards the ethnic Chinese, from my observation is they don't really do so much. No, they're really targeting the regular Southeast Asians. In fact, there might be some backlash. No, I mean, in the Philippine case, for example, the ethnic Chinese, they really see themselves as very distinct from mainland Chinese. No, so there's a distinction between the ethnic Chinese who've been living or several generations of Southeast Asia versus the recent Chinese migrants. Now, when we talk about Chinese diplomacy, I think the difference between Chinese and Japanese diplomacy is even in public diplomacy, there is such a thing as you have to be measured in your initiatives. If you are so in your face and then you do it too strong or aggressive, then you will also be seen as being too propagandistic. No? So this is what China is doing. They're actually quite low-key. They don't really emphasize that. Unlike Japan or like US, we are this, we are this. They don't do that. But if there's one advantage that China has over Japan, if I can give an argument, is China has a very clear message. No? We present a clear alternative to the Western or to American-led model of development. And we are trying to show that we are a kind hegemon, no, of sorts, no, for lack of a better term. But Japan, I'm not sure. What is Japan? Human security, freedom of navigation. I mean, there is no single term that encompasses it. So I think this is where Japan needs to catch up, with China.
Okay, thank you very much. I'm not sure if the organizers will let us extend the time or not. Could I have some guidance on that? So according to my watch, we only have, it's 12 o'clock now, which is the time it's supposed to end. There are a couple of very interesting questions still on the board. All right, I'll have one last question, and my apologies to those I'm skipping. Can a group of middle powers, Japan, Australia, Singapore, Germany, control the Indo-Pacific with the support of the US, China, India, Russia, the big four? This new world order is a better solution than US and China competing for dominance. So I guess the question is, can middle powers, including Japan and the Europeans, play a more significant role and not leave it to US-China competition? Somebody want to take that one?
I'll just say briefly that I wrote a paper that was published in Asian Security earlier this year that essentially argues that Japan, although quietly, is stepping up to become the leader of middle powers, providing maritime security in the Western Pacific Ocean. So I think that's quite useful. I think that's a role that Japan can excel at. I think states are cooperatively working together with Japan and enabling it in that role. But I do think that a middle power coalition would be one of the useful stabilizing ways forward in the region.
Okay, with that, I think, again, my apologies to others because a couple of very good questions. We'll have to wrap this up. I'd like to thank the speakers for what I believe is a very interesting session. I'd also like to thank the organizers, the Embassy of Japan and RSIS. And with that, I think we'll call it to a close.